Thank you, Your Honor. Richard Church on behalf of Ms. Worth.
This is the date and time set for sentencing in this matter. And Ms. Working, have you had a chance to go through the pre-sentence report and talk to your attorney about that? Okay. And Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Well, just to the scoring.
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections required.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Briefly, Judge, just a second summary situation with the circumstances of the guidelines as I see it are 0-17 5. The defendant in this particular matter, as indicated in the PSI and also the police reports, indicated the defendant was originally hospitalized with a severe alcohol situation. Then, after being supposedly medically cleared for that particular matter, was released. But then, for reasons which only she may know, went down to the cafeteria of the hospital, was trying to smoke in the smoking zone. They tried to get her to leave. Eventually, the police were called. She got trespassed from the premises. Then she tried to get back in by getting behind the officers. This is her fourth alcohol, substance abuse related conviction, as referenced by her priors in her work history in the 4, 6, and 8. There should be some jail time resolved in regard to this. Not only is this a situation that was completely unnecessary, but then she goes and tries to cause a problem from people who were effectively trying to help her, and the officers were not trying to originally arrest her. They just wanted her to leave the premises. Thank you, Judge.
Thank you, Mr. Church.
So I do agree with some of what the prosecutor indicated here. Ms. Working has some history. Most of the history is older. I think 6 out of her 10 prior things are 10 years or more old. I disagree with the prosecutor, and I think, frankly, the history belies more of an alcohol problem than what he indicated. He indicated a few priors, but frankly, I think there's more than that. If we look back through the history, entry 3 contains a disorderly person drunk. Entry 6 is a controlled substance offense. Entry 7 contains a count of operating while intoxicated, albeit ultimately she didn't plead to that. It contained that. Entry 8 contains an operating while intoxicated as well as an open intoxicants in a vehicle. Entry number 9 contains an open intoxicants in a vehicle. And then, surprise, in this offense, I think it's very, very clear that alcohol was a driving factor. She was at the hospital and she was intoxicated. She made the poor decision to smoke a cigarette where she wasn't supposed to. I don't think you're supposed to anywhere in the hospital, frankly, but she made the decision to do that. That triggers the police to get involved. They tell her, get out of there. They don't want to arrest her. That's clear. They just want her to get out of the hospital because it's causing a disturbance. She's doing something she's not supposed to do there. She then makes the poor decision to go back to the hospital after they told her to get out of there. This isn't a violent offense. She didn't fight with the police. She frankly was told to get out of there, and candidly, as intoxicated people do, she didn't make a very good decision. She did what they told her to and left, and then thought she'd sneak back in. I disagree with the recommendation here. 0 to 11 months, as the guidelines are, there's a presumption against jailing. The history here is mostly misdemeanors with a single controlled substance offense, again, 10 years ago. At that time, she completed the drug court program and candidly appears to have addressed at least the drug problem. The alcohol problem seems to be persistent, and that shows up in the history since then. In that circumstance, with a nonviolent offense, to recommend a straight jail sentence doesn't seem appropriate to me. It would seem to me that the appropriate response here should be aimed at rehabilitation. History has shown that she's done well with rehabilitation. She successfully completed the drug court again about 10 years ago. At that time, she appeared to successfully have addressed that drug issue. I think that the appropriate reaction here is supervision. She's shown that she can do that successfully. It appears as though all of her history, or the vast majority of it, is influenced by drugs and alcohol, more recently alcohol than drugs. A straight jail sentence here seems like a recipe to not address the issue and continue to be back here retreading the same ground. I don't think upfront jail is necessary here in a nonviolent offense with her history. However, even if the court felt some upfront jail was appropriate, I still think that a probationary term and oversight is the right decision here, because I think it's shown to be successful, and given where she's at with her history, it would seem that she should be given an opportunity. Thank you.
Thank you. Ms. Working, anything that you wanted to say today?
Sorry, I'm kind of nervous, but just wanted to say that I was sorry to the community, the police officers that were involved. They were just trying to do their job. It made it more difficult. And the last few months, I have been making strides to like get my alcohol under wraps, and I've been doing counseling and like with AA and stuff, and I can get there, and I'm just trying to, I don't know, hopefully get that under wraps so that way I can, you know, be a productive member. So
I did read through the report, so I'm familiar with what happened in the circumstance, and there's a lot of information in that report about you and your circumstances as well, so I read through all of that. I take all of that into consideration along with what you've had to say and what the lawyers had to say here today as well. And there's a couple things that stick out to me about this incident itself. It sounds like, just based on your statement that I read, that you really don't remember, what happened, and which tells me, you drank enough to get into a blackout kind of state where you're no longer really making any voluntary decisions, conscious decisions. And the problem with that, obviously, is you're not able to stop yourself even when you're doing something that's completely inappropriate, like in this situation where, I think even the smoking in the hospital, if you would have just left, the police probably would have even been called in the first place. So you just kept compounding this by your behavior, which I don't think at that point you were really in control of, consciously anyway. And that creates a problem for everybody, because now you're not controlling what you're doing. So now everybody else has to kind of babysit you and keep you in line. And that's not really the police. It's not their job, certainly not the hospital staff's job. So it's concerning that you get yourself into that kind of condition where you can't make real decisions about what you should or shouldn't do, and that you put everybody else at risk because your behavior at that point is completely unpredictable. Nobody knows what you're going to do next. And so it puts the hospital in jeopardy, puts all the people there in jeopardy. You're taking time and resources away from people who need it. And then, of course, from law enforcement, who could be responding to more important calls during this time, instead of trying to convince somebody who's so intoxicated they don't know what they're doing to stop smoking in a hospital and to stop going back into the hospital. In terms of, your past history, I think it's notable you've had 5 past jail sentences. You've been on probation 5 times in the past, according to the report. And I think it's great that you did well while you were on probation. A lot of people don't. And I think that does say something about you. Like when you're forced to, you're able to comply and able to do what you need to do. What's concerning to me is after 5 times, you still haven't made that transition from doing it because the court's making you do it, or your probation officer's making you do it, and doing it because that's what you're supposed to do. And I think Mr. Trush certainly may make some good points about how the court should proceed. I view it a little bit differently in that at some point you got to start doing this on your own, we can't just put you on probation for the rest of your life so that you behave in an appropriate way. At some point, after 5 times, the purpose of probation, in my view, is to give somebody a chance who made a bad decision, got themselves into a bad spot, to have some supervision over them, to get them back on the right track, and to show them what they need to be doing. It's not like a way to just control somebody's behavior throughout their entire adult life. And I think that's where we're headed with you. After 5 times, if you haven't kind of got it figured out, more supervision is a temporary fix. So at some point, you've got to make the decision that you're going to change, that you're going to do things differently because that's what you want to do, not because that's what the court's making you do. And we're at that point now where I'm not willing to commit the resources of the court to continue doing the same thing over and over again without any change in really your behavior. So I do think a jail sentence is appropriate. For those reasons, because of your past opportunities to avoid jail, to correct your behavior through probation, haven't been successful. So at this point, I don't think probation is appropriate anymore. I do think jail is appropriate given your behavior here and your past history. The guidelines are 0 to 11. The court is going to impose a 6-month sentence. I am going to require that you only serve 90 days of that up front. After 90 days, if you're eligible for the work camp, I don't have an objection to you being released to do the work camp for the last 3 months. If you can find some treatment and get yourself into treatment, I don't have an objection to you being released after 90 days to go to treatment either, because I do think that would help. But again, I think we're at the point where if that's what you want to do, you need to do that on your own. So the sentence of the court is, again, 6 months in the Otsego County Jail. You do have credit for 2 days served. The court's going to order that you serve the first 30 days of that up front, or sorry, 90 days of that up front. The court has no objection to your release to either the work camp or treatment after that 90 days. If you're not eligible for either of those, then you would need to serve that entire 6 months. The court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Trush, if you can have this working.
All right, let's talk about that, Dot. We just watched a sentencing hearing presided over by Judge George Mertz. And I have to say this one was a blend of patience, accountability, and a bit of courtroom reality check. Judge Mertz maintained a calm and composed demeanor throughout, even while delivering a firm message. You could see he's not quick to anger, but he also doesn't sugarcoat anything. When it was time to deliver the sentence, he struck a careful balance, a jail term with the possibility of early release for treatment or work camp. That tells me he's not interested in punishment for punishment's sake. But he's also drawing a line in the sand. He's not going to keep putting the system on repeat for someone who's had multiple chances and hasn't stuck the landing. The defendant, Miss Working, came across as nervous but sincere during her brief statement. She acknowledged the incident, took responsibility, and expressed remorse for making things harder on the officers and the hospital staff. Her voice was shaky, but the message was clear she's trying. She mentioned counseling and AA, and you could tell she's grappling with this pattern of behavior. That said, Judge Mertz pointed out something that hits home. It's one thing to do the right thing when the court's watching, and another to do it because you've made that choice for yourself. As for the attorneys Richard Trush represented, Miss Working came prepared with a thoughtful argument. He acknowledged her past, but emphasized the nonviolent nature of the offense and pushed for supervision over incarceration. He clearly wanted the court to see the value in rehabilitation and leaned into her previous success in drug court. He made a solid case, but ultimately the judge saw things a little differently. The prosecutor kept it tight and straightforward, laying out the incident and her history, though, interestingly, defense counsel actually argued for a longer view of her past issues than the prosecutor initially offered. That's not something you see every day. Now let's talk about the incident. Miss Working, after being hospitalized and medically cleared, went to smoke in a non-smoking area of the hospital. That led to some friction with staff, a call to the police, and ultimately a trespassing situation. Then came the kicker: she tried to re-enter by dodging around officers. The judge didn't find this funny, but he did walk us through it with almost clinical clarity, noting how this wasn't a violent offense, but it still drained resources and put people at risk. There were no outbursts or dramatic moments in the courtroom, but you could feel the weight of accumulated history pressing down. The atmosphere was respectful, if a bit somber, with everyone understanding this was a pivotal moment. All in all, the hearing highlighted a core tension in the justice system. How many chances should someone get? Miss Working's been on probation 5 times, completed drug court, and had multiple stints in jail. Judge Mertz seems to genuinely believe she has the potential to turn things around, but not without some consequences that signal the seriousness of the situation. He gave her 90 days up front with flexibility afterward for treatment or work camp, which seems fair. She's got a road ahead, but the door isn't shut. It's just a little heavier now. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.